Hi everyone, great to have you with us today, and thanks for joining us for Barty Perry's Local Government Virtual Forum. For those who I haven't met, my name is Laura Raphael and I am a partner in our property and planning team, and I'm really pleased to be joined today by my colleague Monique Lewis. Together we will be talking about enforcement options for unauthorised building work. Before we begin, I'd like to start by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respects to their elders, past and present, and recognise their continuing connection to our land, waters and culture. I extend my respect to the Aboriginal and Torres Strait Islander peoples here today. So just a couple of quick housekeeping notes before we dive in. If you've got any questions, just pop them in the chat at any time. We'll come back to them at the end. After today, we'll send you the slides and a recording, plus also a short survey. It will only take a minute to fill in, and we would really appreciate your feedback. And also just a quick note before we begin, in order to provide you with practical insight and guidance on navigating unauthorised development within your respective LGAs, we have done some research and referenced a number of recent and relevant Land and Environment Court decisions involving various councils. But please be assured it's not our intention in any way to single out or criticise any particular council, but rather our aim is to share these key lessons and outcomes from these cases to support your work and inform best practice moving forward. In our view, we're all on the same council team, and by learning from one another's experiences, councils can collectively improve how they manage and respond to these challenges. Okay, so now over to Monique, who will be starting off with a discussion on BICs.
Hi everyone. As Laura introduced, my name is Monique and I am a lawyer in the property and planning team at Barty Perry. And today I will be starting off our presentation about enforcement options for unauthorised buildings with a quick rundown on building information certificates, when and how they can be used. It would be known all too well for those here today that buildings can and often are constructed unlawfully. And this can be for a range of reasons, but some common examples include buildings that are built without development consent or not in accordance with the conditions of consent, or without construction certificates having been obtained or not in accordance with the construction certificates issues. BICs are often considered a form of retrospective approval that regularises unauthorised building works which have been built without the necessary development consent or construction certificates. However, legally, a BIC does not actually approve or legitimise unauthorised building works. A BIC merely provides an assurance that council will not take compliance actions, such as issuing an order or commencing proceedings seeking orders in relation to the unauthorised building works, such as that the works be repaired, demolished, altered or rebuilt. A BIC can be issued in relation to a whole or a part of a building that has been constructed unlawfully, and a BIC applies indefinitely to the unauthorised building works, except for matters arising from deterioration or fair wear and tear. So as a BIC prevents council from taking action against those works, it is crucial that councils carefully assess BIC applications. And the primary question in this assessment process is whether council is entitled to issue any order or commence proceedings against the unauthorised works, and whether council should do so. And we will explore this in more depth. We'll start by looking at the legal framework that governs BICs. So BICs are issued by local councils under Division 6.7 of the Environmental Planning and Assessment Act. You'll see here Section 6.24 provides that a council is required to issue a building information certificate as soon as practicable after an application is made to council, and that the regulations prescribe the form and manner in which a BIC is issued. It's clause 289 of the EPA regulations, which provide that detail. You'll see at section 2 that a building information certificate must contain the following information. So a description of the buildings, whole or part, including the site address, the day on which the building or part of the building was inspected by council, a statement from council confirming that council is satisfied about certain matters set out, which we'll look at next, and a statement set out that describes the effect of the BIC in accordance with section 6.25 and the date of the BIC being issued. So section 6.25 of the EPA Act sets out what matters must be considered by councils when considering a BIC application. So as you will see at 1A, council is to consider whether council should, under the Local Government Act or the EPA Act, make any order for the building to be repaired, demolished, altered, added to, or rebuilt, or take proceedings for an order or injunction in relation to the works, or take proceedings in relation to any encroachment by the building onto land vested in or under the control of council, or any other such matter. So in summary, the primary issue that councils need to consider when deciding whether to issue a BIC is whether council is entitled to issue an order or commence proceedings for the building to be demolished, altered, added to, or repaired, and whether council should do so. So councils have quite a wide discretion in this assessment process, and consideration should be given to whether the works comply with relevant planning instruments, including your LEPs, your DCPs, and your SEPs. The wide discretion afforded to councils by section 6.25 is exacerbated by the fact that the EPA Act nor the regulations provide any requirement for councils to undertake a merit assessment when assessing a BIC application. However, our advice is that councils should consider undertaking an assessment similar to a merit assessment of a development application. So using section 4.15 of the EPA Act as a guide to consider the likely impacts of the unauthorised works and whether council would have granted development consent in relation to those works had a development application been lodged. A key merit factor that councils will typically consider is the structural adequacy of the unauthorised works. So councils may request the applicant to supply information such as building and engineering plans, reports and certificates to assist council's review of the BIC application and the merit assessment of the unauthorised works. This quasi-merit assessment approach will assist councils in considering whether to grant the BIC or whether to take further action, such as issuing a development control order or commencing legal proceedings in respect of the unauthorised works. As stated earlier, BICs apply indefinitely, with the exception of matters arising from deterioration. And as such, it is important that the description of the works is accurate. This is also important as a BIC application cannot be amended. So we've seen this impact in the Environment Court Proceedings, where applicants have sought to rely on amended materials, and councils have contended that relying on amended materials is amending the BIC, which is not permitted by the EPA regulations, and the court has upheld this position. We do recommend keeping a watchful eye for amendments to the EPA regulations to allow BIC applications to be amended, but for now, BIC applications cannot be amended. So where a BIC application does not accurately describe the unauthorised works or provide the required detail for council to assess the BIC application and be satisfied to issue the certificate, then a BIC application should be returned outlining the insufficient details. As stated earlier, the EPA Act and regulations provide quite limited guidance for what councils need to consider when assessing BIC applications. But councils should consider whether the building meets relevant building standards, such as BCA standards, in assessing the structural adequacy of the unauthorised building works. As it goes without saying that council should not issue a BIC for unauthorised works which fail to comply with structural and safety standards. Additionally, consideration of the structural adequacy and safety standards ties in with consideration of the public interest. And council should consider whether the unauthorised works pose any public safety risk, environmental risk, or other risk, such as hazard of flooding or contamination. Again, we recommend that councils use section 4.15 of the EPA Act as a merit assessment guide, as in doing so, councils would consider whether the unauthorised works are in the public interest. Lastly, we note that the court has continued to hold that past unlawful use is not a relevant factor when assessing a BIC application. So when councils are conducting this quasi-merit assessment of unauthorised works, councils are to assess the unauthorised works and the BIC application purely on its merits, and council is not to take into account any past unlawful use of the unauthorised works. So if council chooses to refuse a BIC application, the notice of decision must clearly set out the reasons for refusal. So those reasons should be sufficiently detailed and set out what works would be required to enable council to issue a BIC. Applicants are entitled to appeal BIC application refusals where council has failed to issue a BIC within the prescribed period or respond to the BIC application, or where the applicant is dissatisfied with council's decision to refuse the BIC application. On an appeal, the court will step in and undertake a quasi-merit assessment of the BIC application and the notice of refusal. So the court will consider whether to exercise its powers to direct council to issue the BIC, or revoke or alter the BIC, or confirm a notice to supply further information related to the BIC application, or any other orders that the court considers to be appropriate. So it is crucial that councils carefully consider what works council say would be required in the refusal notice for council to issue a BIC, as the notice of refusal will become the focus of the court's assessment on appeal. So it is essential that councils carefully consider these legal and merit considerations when considering whether to issue a BIC, as interested parties such as neighbouring landowners may consider council's decision to issue a BIC unlawful and may decide to commence judicial review proceedings. On a judicial review proceedings, the court will consider whether council properly assessed the impacts of the unauthorised works in accordance with the EPA Act and regulations. If the court finds that council has failed to properly consider the impacts of the unauthorised works and finds that council should have issued an order or commenced proceedings in respect of the works, then the BIC would be revoked and council may be subject to a cost order. Councils should also be particularly cautious of potential judicial review proceedings where a BIC application required a careful assessment of impact on public safety or environmental harm. And council should also be cautious of potential negligence or damages claims. So if council issues a BIC for unauthorised works, which later cause harm, resulting from significant structural adequacy or safety issues, then council could find themselves being held liable for not undertaking a proper assessment of the BIC application of those unauthorised works. So as stated, a BIC only prevents council from taking action against the construction of unauthorised works. So BICs are not capable of authorising the use of unauthorised works. So if a DA is not lodged seeking consent for the use of the unauthorised works, the subject of the BIC, then council remains able to take action to prevent the use of the unauthorised works, even if a BIC is issued. So applicants must lodge a development application seeking consent or a modification application to seek consent for the use of the unauthorised works. And this consent would only authorise the future use of the works and does not retrospectively authorise the use or the construction of the unauthorised works. In the key case of Ku-ring-gai Council and Biozo, the court made it clear that a development consent cannot retrospectively authorise unauthorised works. An existing development consent cannot be modified to retrospectively authorise unauthorised works. However, a development consent can be granted or a modification application can be granted to authorise the future use of the unauthorised works going forward. So in Biozo, the court also made it clear that the issuing of a BIC for unauthorised works and the granting of a development consent or a modification application for the future use of the unauthorised works does not cure that breach of Section 4.2 of the EPA Act, that is the carrying out of development not in accordance with development consent. Now, councils frequently deal with BIC applications and DAs concurrently, and the court has held that the proper sequence is to regularise the unlawful works and the use of a building by first assessing the BIC application and then assessing the DA seeking consent for use.
Okay. Now turning to the do's and don'ts of DCOs. Development control orders, or DCOs, are a critical tool used by planning authorities such as councils to ensure compliance and safety under New South Wales planning regulations. Issuing DCOs can be complex as councils must ensure that it is validly drafted, that it adheres to the relevant statutory requirements, and that it strikes an appropriate balance between the public interest and any potential hardship to the recipient. So this section of our presentation will focus on the crucial importance of accurately preparing the initial notice of intention and draft DCO. And doing so will help minimise the risk of costly delays, avoid time-consuming queries from recipients, and can also reduce the likelihood of appeals challenging the validity of the DCO. Issuing a DCO may appear to be a simple task on face value. However, council officers are often faced with unusual circumstances which have potential to evolve into complex legal scenarios if not dealt with carefully. The first step in reducing the likelihood of such scenarios occurring is understanding the importance of the contents in the notice of intention to issue a DCO and the DCO itself. Because you have to remember that once a DCO is appealed to the court or council chooses to initiate enforcement proceedings, the DCO will become the primary document. It will be heavily interrogated and scrutinised by numerous parties to find any fault to be argued, especially by lawyers. So let's turn to the do's. You have to ensure that the DCO is well drafted and that it states the specific problem, clearly outlining what is wrong and the steps required to remedy the situation. When drafting development control orders, the following principles should be adopted to ensure clarity and enforceability in the event of a breach. 1. Use clear and specific language. Orders should be written in plain English, leaving minimal room for ambiguity or misinterpretation by the reader. 2. Early and clear communication. Orders must clearly communicate the specific actions required and the rationale behind them. The actions required by the recipient and the deadline for compliance must also be explicitly stated and clearly visible on the document. 3. Avoid language requiring future conduct. The language used in the order should not suggest any future intentions by council. The order must only include the obligations or requirements being imposed at the time of issue. 4. Consistency. The terminology used in the order should be consistent throughout the whole document, especially when making reference to the breach and any actions required to be undertaken. 5. Refer to specific records and evidence. So this includes the dates of site inspections undertaken by the various council compliance officers, the description of the unauthorised development that was observed by these relevant council officers, and photographic evidence where possible. And 6. Refer to the specific provision of the EPA Act and or other planning instruments which have been contravened. It is crucial that councils maintain thorough documentation and evidence to support any order that has been issued. So this will include a record of the history of compliance issues with respect to this property, detailed file notes of the site inspections that were undertaken by the council officers, the photographs, even just aerial imagery of the site over time, and also all previous communications with the affected parties or their representatives. So this includes every single email or file notes of telephone discussions that were had, because this documentation will become evidence in the event of court proceedings. So whether that be the recipient commencing court proceedings challenging the validity of that DCO, or separately counsel choosing to commence enforcement proceedings later down the track. The matter of Ballina Shire Council and Jublin illustrates the impact of vague wording and ambiguous language on the validity of a DCO. So in this matter, council had issued a DCO to the owner of the property, requiring the demolition of an in-ground swimming pool on the basis that it was dilapidated and that it posed a danger to public safety. The owner of the property then contested the order on the grounds of validity due to the contents being unclear and lacking specificity. And Justice Robson had emphasised that for an order to be enforceable, it must be expressed in clear and unambiguous terms. And specifically, he identified that a phrase such as council advises that it will issue you with the order, which could have been just an innocent mistake left into the DCO, introduced elements of uncertain future conduct by council making it unclear whether compliance was required immediately or at a later date. So this case illustrates that whilst an order may be issued lawfully and while my council may do the right thing, the court may still find that it is invalid. So it's extra important to double check the wording of the DCO before you issue it. So going back to the do's, ensure the order is well grounded and falls within the scope of an order in Schedule 5 of the Act. The order should be based on clear breaches of planning laws or development consent conditions, and that does not go beyond what council ultimately wishes to achieve. So we turn to the case of Kingfisher Properties and Northern Beaches Council, which involved an appeal to the LEC against a $100,000 fine imposed by the local court for failing to comply with a development control order. So what had happened in this matter is that council had issued a DCO in relation to a carport that had been constructed without development consent. So following non-compliance, Kingfisher was then issued with a penalty infringement notice and elected to have the matter determined by the local court, where he pled guilty to the offence. But he then appealed the severity of the penalty, being the $100,000 fine, enforced by the local court to the LEC, where it was found that the circumstances did not exist for council to issue a DCO, and that as a result of the terms of the DCO, they were also outside the scope of council's powers. So council had originally issued the DCO as Category 11 compliance order. However, following a conciliation conference, the parties agreed to change the DCO to a Category 3 demolish works order, which, as you all know, can only require a party to demolish or remove a building. So while the DCO did require the removal of the carport roof, the terms had numerous other requirements that went beyond the scope of a demolish works order, such as the construction of a replacement roof with guttering, the submission of a works as executed survey plan for the building work required to be constructed, and the certification of any stormwater drainage works required to be constructed. So in his judgment, Justice Preston noted that while council had the power to issue a DCO for the demolition of the unlawfully erected carport, it did not have the power to order the resident to then undertake the construction of new building work under the scope of a demolish work order. So this judgment highlights the importance of selecting the correct category or categories from Schedule 5 for a DCO to remedy unauthorised works, particularly where those works already comply with the required development standards. So it just serves as a reminder that it is crucial to be familiar with and to review the table at Schedule 5 of the Act when drafting a DCO, and that the correct categories of orders have been included. Even if it's multiple, just include them within the DCO, because you may be stuck later down the track and not being able to seek some different orders or construction work or whatnot through those DCOs. And 3, provide a clear time frame for compliance. So include a reasonable deadline for compliance, ensuring the order is achievable. So determining a reasonable time frame for compliance with a DCO may become a complex and challenging task when dealing with the unusual scenarios your council officers often find yourselves confronted with. So pursuant to Clause 27 of Schedule 5 of the Act, a DCO must provide a reasonable deadline for the terms of the DCO to be complied with. So under clauses 27.1 and 27.2 of the Act, councils may only require immediate compliance with the DCO in circumstances involving a serious risk to health or safety or in an emergency. However, the court had confirmed in the decision of Waverley Council and Ash Samadhi and others that clause 27 does not operate as an exhaustive list of circumstances in which immediate compliance may be justified. And it instead found that an interpretation of the reasonable period test pursuant to clause 27 requires an assessment of the particular facts of each case and is dependent on the nature of the order, what is required to achieve compliance, and what are the known circumstances present that may influence the determination of a period that is, in those circumstances, reasonable. So now we turn to the don'ts. So 1, don't be unreasonable and ensure proportionality. The order must be reasonable in scope and tailored to the specific issues at hand. If a DCO is issued without properly complying with the parameters set out by Schedule 5 of the Act, it may be susceptible to invalidation. So going back to the decision of Kingfisher, the court reduced the fine for non-compliance with the DCO from $100,000 to only $9,000 on the basis that the requirements under the DCO went beyond the scope of a demolished works order. So while issuing DCOs may appear to be a simple task, this case illustrates that even after a recipient pleads guilty, complex questions of law may arise. So in order for council to have the greatest prospects of success, a DCO must be proportionate, appropriate, and reasonable response to the issue, and it cannot be unreasonable. Otherwise, it may open itself to challenge. The reasonableness of a DCO depends on whether the terms can be justified and are intelligible in the circumstances. 2, don't require action beyond what council actually wants to see on site. So for example, if a secondary dwelling is permissible, but it was constructed without consent, a DCO should not require demolition of the entire secondary dwelling, but rather should focus on any part of that building that may not comply, for instance, an awning. In our experience, it is very unlikely that if a court is asked to determine the validity of a DCO requiring such demolition, that it would find such an extreme request as being reasonable. So instead, the DCO should limit the demolition to the non-compliant parts of the building and then make reference possibly to the lodgement of a BIC application or to further information that council requires to satisfy itself. 3, don't use DCOs for unrelated issues. So ensure the order addresses only the specific matter at hand, so that is the unauthorised development, and that it does not extend to unrelated issues. 4, don't use the DCO for minor issues up front. So if the breach is minor and it doesn't pose significant risks, council should consider alternatives like negotiations or warnings at first instance. 5, don't overlook procedural fairness. Make sure that the affected parties are given the chance to respond before an order is issued and demonstrate that their response has been considered, because failing to do so could undermine the legitimacy of the DCO. So before issuing a DCO, as you know, enforcement authorities must observe the requirements of natural justice, which includes issuing a notice of intention to the recipient, the terms of the proposed order, and the proposed order for a period for compliance with that order. And then the recipient has the opportunity to make representations regarding that draft order. Those representations made by an individual who receives a draft DCO are relevant considerations that must be taken into account by council. They must be given more attention than mere lip service, and they must be meaningfully, genuinely, and properly considered by enforcement authorities to avoid a challenge to the DCO. So this is crucial, as any failure to consider representations made by the recipient of a DCO or a notice of intention may create the circumstances for an appeal on the basis of invalidity. So in order to protect council's interest, some mitigation measures which may be implemented include maintaining a record of how representations have been taken into account by council. So even if it's just file notes on council's system, referring to the representations in any subsequent correspondence to the recipient, including reference to the date those representations were received and how they were received, for example, by way of email, and providing reasons why the representations have not resulted in reduction or revocation of the DCO. So a repetitive practice across New South Wales councils, which has resulted in the invalidity of numerous DCOs, is the exercise of essentially copying and pasting the relevant column or row in Schedule 5 of the Act when detailing the offence or breach, without providing any specific detail of the property in question. But this, of course, is going to create an opportunity for the DCO to be appealed, as the recipient may claim that the reasons provided are insufficient and ambiguous. So rather than merely identifying a category from Schedule 5, specific details of the property and the breach itself, including the circumstances, should be included. So even going back to my previous comment in relation to just including photographic evidence, that always helps to make it directed to the property at issue. As you have heard me say today, poor drafting of a DCO can have severe implications, particularly in circumstances where the DCO is challenged through to the LEC. And we are seeing a lot more of these Class 1 appeals commenced by recipients of DCO challenging their validity. So just to recap, when drafting a notice of intention or DCO, the terms of the order must be certain and clear. The terms of the order must be reasonable and proportionate. The period for compliance must be reasonable. Reasons for giving the order must be provided, and you must invite the recipient to make representations in their defence. So in the event that council is uncertain in how a sensitive matter should be dealt with, council should consider obtaining legal advice, and we say so for the following reasons. Expertise. A planning lawyer has the expertise to interpret planning laws and regulations and identify any other possible breaches or provisions that can be referenced within the DCO. Risk mitigation. Legal advice can help identify potential risk and liabilities and provide council with guidance on drafting to ensure the desired outcome is achieved, and also reducing the likelihood of DCOs being challenged through Class 1 proceedings. So even if a DCO is very well drafted, as I'm sure you all know, there will still be instances where they are challenged through to the LEC, particularly by self-represented litigants. So when this occurs, council should remember and consider the powers provided to the court under Division 8.5 of the Act to revoke the DCO, modify the DCO, substitute for the DCO any other order that the relevant enforcement authority who gave the order could have given, find that the DCO is sufficiently complied with, make such order with respect to compliance with the DCO as the court thinks fit, and make such order with respect to the DCO as the court sees fit. Again, we have relied on the powers provided under this division several times this year on challenges to the DCO. So, for example, the parties have managed through the Section 34 process to reach agreement on the outcome and the works to be undertaken to rectify some unauthorised works. But this agreement was not consistent with the DCO that council had originally issued. So what we did was that we, through the Section 34 agreement, we asked the court to modify the DCO. So we physically modified the DCO ourselves and we annexed that to a Section 34 agreement that was filed with the court. Okay, so having considered some of the more upfront options for council, such as BICs and DCOs, we can turn our mind to council's legal options where the aforementioned parts don't work. So before initiating any Class 4 or Class 5 proceedings, it is essential that the council ensures all informal avenues have been thoroughly exhausted, and the court will want to see evidence of this in commencing any proceedings. So this includes confirming that any DCO issued is legally sound and that it has been properly served to the relevant party. Once a DCO has been issued and if the recipient fails to comply, the council may attempt further communication to encourage voluntary compliance. However, this approach may prove ineffective, especially if the individual or recipient has already demonstrated a pattern of non-compliance with DCOs. In circumstances where the breach is ongoing, serious, or causing harm to public interest or amenity, we would suggest that legal engagement become a necessary step, with a letter to be sent by a lawyer clearly outlining the council's position, requesting a reasonable response from the recipient. So, for example, requesting that a written undertaking be provided within, say, 7 or 14 days, detailing when every aspect of the DCO will be complied with, but also a warning that failure to reply to our letter or to comply will result in proceedings being commenced in the Land and Environment Court. Often, a letter from a lawyer is sufficient to signal to the wrongdoer that the council is actually serious about enforcement. And we have a strong track record of successfully assisting councils in achieving desired outcomes simply through the issuance of these formal letters to landowners without the need to commence proceedings. If, despite the legal letter, compliance is still not achieved, then councils can then consider commencing Class 4 or Class 5 proceedings in the LEC, something Monique will now talk to you about.
So one option available to councils is to commence Class 4 proceedings in the Land and Environment Court. These are civil enforcement proceedings in which councils can request the court to make orders enforcing relevant planning laws in respect of unauthorised works. Class 4 proceedings are typically commenced when informal enforcement measures, such as issuing development control orders or correspondence, as Laura has just explained in depth, has failed to resolve in the unauthorised works being properly addressed. As Class 4 proceedings are civil proceedings, the burden is the balance of probabilities, which is lower than the criminal standard, which is required for Class 5 proceedings. So Class 4 proceedings are more accessible and a more efficient pathway for councils seeking to compel compliance through court-imposed orders. Where councils have validly issued a DCO, the court will typically make orders for the payment of council's cost of the proceedings. Further, when councils are successful in obtaining orders compelling compliance, any non-compliance with court orders can also allow council to commence further contempt proceedings. The court may also make other ancillary orders in Class 4 proceedings that it sees fit, such as orders for the restoration or remediation of the subject land. So the case of Queanbeyan, Pallarine Council and Walker demonstrates how councils can utilise Class 4 proceedings. So in these proceedings, the landowners carried out works, including earthworks, including the placement of fill in 2 large mounds, the erection of a concrete slab upon one of those mounds, the construction of a driveway access, and construction of an internal dirt access road on a site. Council received complaints from members of the public regarding the works and carried out inspections, and subsequently issued several DCOs, including demolish and restore works orders. The landowners lodged a development application seeking consent for works on the site. Council refused that DA, and the landowners appealed, commenced Class 1 proceedings appealing the refusal of the DA, and the court refused to grant the DA in those proceedings. Following that, council commenced Class 4 proceedings under Section 9.45 of the EPA Act, seeking declarations that the landowners carried out development on the land which was only permissible with development consent and without obtaining such consent, which contravened Section 4.2 of the EPA Act. And council also sought orders under Section 9.37 of the EPA Act that the landowners failed to comply with the several DCO orders issued by council in relation to the unauthorised works. And council also sought orders that permitted, in the event that the landowners failed to comply with the court's orders, an order permitting council to enter upon the land to carry out the works the subject of the orders and recover the costs of such works from the landowners. So council filed a number of affidavits in these proceedings from council officers describing the extent and nature of the unauthorised works and the environmental consequences arising from those works. And the court was satisfied by the evidence provided by council and made orders in accordance with those sought by council, including the order that if the landowners did not comply with the demolition and rectification works within 1 month, that council may enter the land and do all such things as required by those orders at the expense of the landowners. The court also made orders that the landowners pay council's costs of commencing the Class 4 proceedings. So this case serves as a good clear-cut example of the court's jurisdiction and powers with respect to making orders, compelling compliance works to be undertaken, and also the court's power to authorise council to enter onto private land to carry out such compliance works. Alternatively, councils may commence Class 5 proceedings against breaches of planning laws. These are criminal enforcement proceedings, which are typically commenced in relation to more serious or repeated breaches of environmental planning laws, for matters such as the unauthorised demolition of heritage items or more large-scale works that have resulted in significant environmental harm. So when councils are considering whether to commence Class 5 proceedings in relation to unauthorised building works, councils should consider whether the unauthorised building works are serious enough to warrant criminal sanctions by the court, or whether the Class 4 civil enforcement pathway may be more sufficient and appropriate. As these are criminal proceedings, the burden of proof is beyond a reasonable doubt, and this is significantly higher than the threshold in Class 4 proceedings. Given the nature of these proceedings being criminal, they are typically more resource intensive due to that higher evidentiary threshold to meet the standard of the burden of proof. So where the burden of proof is met by councils, the court may impose significant fines and other orders such as clean-up orders and environmental service orders. And in Class 5 proceedings, the court may also consider aggravating and mitigating factors when determining penalties. And this includes any prior warnings from council, cooperation from the landowners, and the impact of the unauthorised works on the community. So looking at the case of Burwood and Alum, in these proceedings, the landowner obtains consent from council for the partial demolition of a listed item of local heritage significance. However, council became aware that unauthorised internal works to walls and ceilings had been carried out, not in accordance with that development consent, and council issued a DCO for the landowner to immediately stop works. After council conducted some site inspections, further DCOs were issued requiring restoration works. Council then commenced the Class 5 proceedings seeking charges for the carrying out of development other than in accordance with a development consent. The landowner, who was the defendant to the proceedings, pled guilty to the nature and extent of the demolition works particularised by council's charges. So the court's role in these proceedings then became to determine the seriousness of the offence and the circumstances to determine an appropriate sentence. So in doing so, the court considers the purposes under the Crimes Sentencing Procedure Act for aggravating and mitigating factors. The court also considered the objective seriousness of the offences and considered whether the landowners committed the offences intentionally, that is, with an intention to breach the relevant planning laws. The court also considered the maximum penalty available for each of the offences under Section 9.53 of the EPA Act. And in considering all of these things, the court concluded to order the landowner to pay a fine of $46,000 and also pay council's legal costs of the proceedings in an agreed amount of $26,000. So these proceedings highlight the seriousness with which the court will treat unauthorised demolition of heritage items, and it also highlights what matters the court will consider in determining appropriate sentences for criminal matters. So where councils are successful in obtaining orders in either Class 4 or Class 5 proceedings for landowners to do certain things, such as complete rectification works or pay fees to council, and the landowners fail to comply with those orders, councils can bring further contempt proceedings against landowners for being in contempt of the court's orders. Now, these are separate proceedings to the original Class 4 or Class 5 proceedings, and they require proof of non-compliance with the court's orders. So, for example, something we see in Class 4 proceedings quite often is councils successfully obtaining orders requiring landowners to demolish or rectify unauthorised building works within a certain time frame, and landowners failing to do so. So in this case, we typically assist councils by drafting and sending letters to those landowners. We refer to the court orders made, the date, note the non-compliance having not been achieved, and ask the landowners to provide some sort of response. Now, absent any satisfactory response from the landowners, we will then proceed to advise council to commence contempt proceedings. And by asking the landowner to respond to those matters in that letter, this reflects favourably on council as an attempt to resolve the matter outside of court, and also that the decision to commence contempt proceedings is a serious decision based on the landowner's non-compliance with the court's orders. So this would assist council in demonstrating that the landowner knew of the orders and has chosen not to comply with those orders. And councils can then seek penalties against the landowner for being in contempt of the court. And those penalties can be significant fines and even imprisonment.
So to conclude, it's important to remember that the foundation of successful enforcement proceedings lies within the DCO itself. So the DCO must be carefully drafted to ensure it is reasonable, it is clear, and it is firmly within the council's scope of powers. A poorly drafted or defective DCO can seriously undermine enforcement efforts, and it may leave the council vulnerable to legal challenges or even adverse cost orders. And it's also important to highlight that in enforcement proceedings, costs are typically awarded in favour of the council. However, provided that the proceedings are brought reasonably and properly. And this is especially the case when enforcement aligns with the council's statutory powers, it serves the public interest, and it's based on a properly issued DCO. So if you have any questions, please feel free to pop them into the chat. And while we wait for that to occur, something that Monique and I were discussing in preparation is that something that we actually do get asked quite often is whether a council should issue a penalty infringement notice for a serious offence. And one thing we do bring to council's attention is that if council is contemplating the potential commencement of enforcement proceedings in the future, so whether that be Class 4 or Class 5, if a PIN is issued and then subsequently paid, this typically prevents council from commencing proceedings with respect to that same offence. So this is something councils should keep in mind for these serious offences or these difficult landowners that they've been dealing with. And if you're thinking that you may need or may have no choice but to commence proceedings in the future, you should possibly consider obtaining legal advice first before issuing any penalty infringement notice. Okay, I'll just see we have another question.
So we have received a question in the chat from Stephen Wallace, and the question is, can or should councils hold off on issuing a BIC until a DA is lodged seeking consent for any use to give some certainty, or should council instead fully rely on their compliance functions? I might answer that question and say I think it would definitely depend on the circumstances of the case. However, we could advise that in assessing a BIC, council could very well issue correspondence to the BIC applicant, notifying that whilst council is assessing this BIC, council notes that the BIC would not authorise any future use, and if that use is inconsistent with any existing development consent, then the applicant needs to also lodge a development application or a modification application to address the use question. So our advice would be to raise this with the BIC applicant to let them know that that is what they need to do.
We've just received a second question. Can a second DCO be issued if an initial DCO is resolved by issuing a PIN? I would say not on the same offence, as you would it would suggest that you've already sought some sort of agreement through the PIN being paid. You've already punished that landowner for that same offence. So, I mean, it could be a different, if there's multiple unauthorised uses or works happening on the site. So, for example, you've got unauthorised shed that has been constructed, and at the same time they're also using that shed for residential purposes, and there's some other building on the site that has been constructed. If the PIN only, so if you issued a DCO separately for just the construction of the shed, you've then had a PIN issued failure to comply with that DCO for the construction of the shed, that PIN has then subsequently been paid. Your future DCO that you should contemplate issuing is in relation to the use of that shed for residential purposes, and also for any unauthorised works on the site.
We have another question. Is it acceptable to issue a demolition order for unauthorised structure unless a BIC is obtained from council?
So the difficulty I see with that is you'll have a recipient of this DCO think, I don't want to demolish this this building, and I'm going to commence, and they'll get legal advice, and the lawyer's likely going to say, well, we should challenge the validity of that DCO through commencing Class 1 proceedings. And as I had said in my presentation, that's likely, the court is unlikely to make such an extreme order. And I mean, through that process, and I had something happen, a similar matter I was assisting a council with this year, and through that process, through the Section 34 process, we were able to agree that we will revoke the DCO on the basis that it required entire demolition, and that we had, agreement that a BIC would be lodged. But the difficulty is that I had suggested to the applicant solicitor, well, we can maintain the DCO. I'm not going to revoke it until such time as we get this BIC lodged. But his response to me was, well, we're going to go to a hearing then, because there is no way I'm going to advise my client that he should settle this if the DCO is not going to be revoked, because at any time council can come and take enforcement action. And I agree. And I had to give that advice to council that we just have to sort this out another way by an agreement that a BIC would be lodged. But obviously you can't just pause court proceedings until such time as that BIC is determined. So we could only ask for it to be lodged. So just a little bit of difficulty there in having some sort of time frame as to when compliance can be accepted or reached. So you could definitely make mention in there that a BIC is required, but I think the first thing that should occur is just this correspondence requiring the BIC, giving warnings to that recipient that this is going to otherwise result in the issuance of a DCO. But you just have to bear in mind what I said in terms of if you're issuing a DCO for demolition of an entire building, if, say, a DA was lodged, what is the likelihood of that building having been approved? So pretend it's not there and they've gone through the right process and actually lodged the DA first. And if the answer is that it's likely that, obviously through the correct information, that DA would have been approved, then it's unlikely that an extreme DCO of demolition of the entire building will also be held to be valid. Okay, that concludes our questions. But oh, sorry, yeah. Correctly described what they really need.
Oh, sorry. So we've got another question in the chat. So to clarify what we mean regarding not being able to amend a BIC. So if the applicant has not correctly described what they really need a BIC to apply for, and the BIC has not been issued, can the application not formally be amended in writing by the BIC applicant, like with a DA? So that's right. So the EPA regulations do not provide for BIC applications to be amended. And we've had this issue come up in Land and Environment Court proceedings.
And Tim, just mindful of the fact that we're running out of time, but we do have your contact email from the attendees list. So what we'll do is we can shoot you through an email with some further points on that. And that goes to anyone else. We have to wrap up today's session, and we thank you so much for spending the time with us, and we really hope you picked up some useful insights. But if you'd like to chat further, or if you think of any questions, please don't hesitate to reach out to Monique or myself. Our contact emails will be on the slides that you'll receive via email. And we hope you enjoy the rest of your day, and to see you at another Barty Perry Forum soon. Thank you.